Oh, there you go. Good morning.
Good morning. I'm just going to give a moment for everybody to log in here.
Yeah, all right.
Good morning.
Good morning. All right, it looks like we have everybody present. So, again, my name is Judge Veronica Long, and this is a hearing in the appeal of Mandelbaum. Before we go on the record, I'm going to go over a couple of announcements to ensure that we are all on the same page. Appellant has elected to enter the small case program, and accordingly, this appeal will be determined by one administrative law judge rather than a panel. The OTA will conduct this hearing electronically with the agreement of all parties. Also present is our stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speaks one at a time and does not speak over one another. Also, please speak clearly and loudly, and when needed, Ms. Alonso will stop the hearing process to ask for clarification. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the OTA website. And the hearing transcript and video recording are both part of the public record. Some general rules to keep in mind for this hearing. Please say your name before you speak. Please do not use the chat feature in Zoom. Please mute your microphone when you are not speaking to avoid feedback and background noise. And if you're calling through a phone connection, you are welcome to use the additional instructions on the Zoom to mute and unmute. As a reminder, this proceeding is a live broadcast and any additional information shared on your screen is publicly viewable. If there are any questions during the process or any questions regarding technology, please direct them to me. If you become disconnected or have technical difficulties, please wait and we will contact you. In the record are marked FTB's Exhibits A through I and Appellant's Exhibits 1 and 2. I'm going to ask if there are any new exhibits or any objections to the existing exhibits. I'm going to begin with Franchise Tax Board.
We currently don't have any new evidence or exhibit things.
All right. And then Mr. Mandelbaum, do you have any new exhibits or any objections to FTB's existing exhibits?
No, I do not.
All right. And as a reminder, we have 25 minutes for appellant's presentation, then 15 for FTB's presentation, and 5 minutes for appellant's closing. Do we have any final questions from either party before we go on the record? I'm going to start with Franchise Tax Board.
Franchise tax boards don't have any things.
All right, Mr. Mandelbaum, do you have any questions before we go on the record?
I'd like to know if you said this hearing is a matter of public record.
Yes.
Can it remain private? Like
No.
not
No, so there is a method to request that a hearing be closed, be made private. And that requires a request to be made in writing in advance of our hearing. Um,
oh
Generally, we are our agency, Office of Tax Appeals, is subject to the act under which we were created is about transparency and taxpayer fairness. So as a matter of just as a threshold matter, nearly all of our hearings are viewable by the public. So you may recall during our pre-hearing conference, I directed you to OTA's YouTube channel. That's where all of the hearings
yeah, I
are.
know. I noticed that yesterday.
Mhm.
Just you're right. I should have put in a request then.
Yes,
Haven't.
if there's any information that you consider to be, private and you don't want to have discussed. So for example, if you were going to discuss like a specific taxable income amount or something to that effect, if it's already in the exhibits or in the briefing, you can just refer to, the exhibit and page of the briefing and we can refer to it that way rather than having you mention it. If that alleviates any of your concern. But as to having the entire hearing closed, that's something that would have had to been requested in advance.
Okay.
All right. Um, so if there's no additional questions, I'm going to go ahead and have us go on the record. Ms. Alonso, are you ready? Yes. All right. Okay, we are now on the record. This is the appeal of Mandelbaum, OTA case number 230513508. Today is Thursday, August 14th, and the time is 9:35 a.m. My name is Judge Veronica Long, and I will be the administrative law judge for this appeal. We are holding this hearing today electronically with the agreement of all of the parties. As a reminder, the OTA is not a court. We are an independent appeals body. OTA is staffed by tax experts and is independent of the state's tax agencies. We do not engage in ex parte communications. Our decisions are based on arguments and evidence provided by parties on appeal in conjunction with appropriate application of law. I have read the briefs and examined the submitted evidence. Can the parties please each identify yourselves by stating your name for the record, beginning with Franchise Tax Board?
My name is Yadi Lee, spelled as Yadili, and I'm with Franchise Tax Board today.
Alyssa Pinerbossi for the Franchise Tax Board.
All right, Mr. Mandelbaum, could you please introduce yourself for the record?
Chuck Mandelbaum. I'm the appellate in the present matter. I appreciate the opportunity to present my argument before the Office of Tax Appeals. And the issue for consideration today is whether the appellate has reasonable cause for the late payment.
Mr. Mandelbaum, I'm sorry, I'm going to interrupt you for just a moment. I just have a few more administrative matters I'm going to get to, and I will let you know when it's your time to present. But I appreciate you're so prepared. So I'm going to just restate the issues in the appeal are: first, whether appellant has established a basis to abate the late payment penalty. And second, whether appellant has established a basis to abate the underpayment of estimated tax penalty. With respect to the evidentiary record, FTB has provided exhibits A through I. Appellant did not object to the admissibility of these exhibits. Therefore, the exhibits are now entered into the record. Appellant has provided exhibits 1 through 2. FTB did not object to the admissibility of these exhibits. Therefore, the exhibits are now entered into the record. No additional exhibits were presented today. And now, Mr. Mandelbaum, you have 25 minutes to present. You may begin whenever you're ready.
Oh, okay. So I can start the oral argument.
Yes, go ahead. You have 25 minutes.
All right. The first part of my oral argument discusses what was paid, how much was paid, stuff like that. You already have that information. I don't know if we need to go through it. What I'm going to do here is start this the other argument with saying that since the appellate default was neither intentional or malicious, I wrote a letter on January 6th to the FTP outlining my circumstances and requesting a refund for the penalties and interest. Following this, he's admitted a reasonable cause, individual fiduciary claim for refund and request an interest abatement to the FTP. However, on April 23rd, 2023, the appellate received a notice of action from the FTP stating that his requests, claims for refund and interest abatement have been denied. Hence, the present appeal before the OTA. According to the California Revenue Tax Code, 19132, late payment penalty is imposed unless a taxpayer is able to demonstrate that the failure to pay on time was due to reasonable cause and not due to willful neglect. The opposing sides argue that the appellant has not met the burden of proof to establish the late payment penalty should be abated for the reasonable cause and also has failed to provide any basis for abating the estimated penalty or interest. The burden of proof to show reasonable cause for late payment rests on the taxpayer, and the appellant respectfully requests the opportunity to demonstrate that he had legitimate and reasonable cause for late payment, which was neither intentional nor neglect. The present situation arose as a result of a mistake that significantly increased the appellant's taxable income to the extent that he had the opportunity to double his tax liability. Since the appellant was not directly involved in handling the estate and was not authorized to access the estate tax information, his ability to obtain essential record was restricted. The specific records would have allowed the appellant to track distributions were taxable. However, it was fully controlled and retained by the estate, the entity unrelated to him. The determination of the taxable percentage of the pellet distribution was entirely under the state's control. The state has not yet determined whether the distributions were taxable or non-taxable income and had neither finalized nor released the crucial information required by the appellate by the tax payment due date. The appellate was further hindered in obtaining relevant information on time because the estate is located in California and access to the data is limited to these individuals who only reside within California and have been authorized by the state. The appellate also resides in New York, which is neither authorized by the state nor could travel to the state's office to retrieve the necessary information due to his personal and work obligations. It was categorically impossible for the appellate to obtain necessary information or documents from any alternative source or through other investigative methods. Despite making multiple verbal requests for the required information, these efforts were in vain. Lacking the ability to reasonably estimate tax liability, with the limited information available, the appellate reached out to the Office of the Vice President of Operations and the Office of the Family Accountant, but received no reply or no positive reply, making it impossible for him to make a reasonable estimate of his tax liability. When the appellate eventually received its Schedule K-1 indicating the taxable amount of income, the underlying document required to confirm his tax liability was not available. He made repeatedly requests for these documents, but with no positive outcome. The appellate submits that he is a law-abiding U.S. citizen has never skirted his duties and responsibilities. This present situation arose solely to circumstances beyond his control, including his lack of involvement in estate matters, inability to access essential records and information, and the estate's failure to provide the necessary information despite his repeated requests. The appellate contacted the estate to request the necessary information that was met with silence. This demonstrates his attempt to make all prudent efforts to obtain the information which a knowledgeable person would have done. Had the state provided information in a timely manner, the present situation would have arisen. The present situation would not have arisen. The law also requires the taxpayer may face obstacles beyond their control, preventing them from meeting their tax obligations on time. Reasonable cause. I'm going to address a little bit of a reasonable cause. To qualify for the reasonable cause exception, a taxpayer must establish that he cannot acquire the information necessary to make reasonable estimates of their tax liability. In the case similar to the appellate's, an appeal of Harry J. Moran, it was determined that appellate, you can refer this case to the opening brief. It was determined that appellate could not have kept his own records in which distributions were taxable because those records were kept by the state, an unrelated entity, and the actual determination of which distributions were taxable was completely controlled by the state and not finalized and released to appellate until late 2016. Despite requests, I don't know if that makes, despite requests for the information of office sooner, the Office of Tax Appeal found this to be reasonable cause for the late payment of tax. In the present matter, the appellate faced a similar situation where the determination of the taxable percentage of his income was controlled by the state. Based on the state records to which the appellate was denied access, in light of appeal of Henry J. Moran, the appellate seeks similar relief.
Mr. Mandelbaum, I'm going to stop you for a moment. Two things. First, I'm going to ask you to please speak louder for our stenographer.
Oh, okay, I'll try.
Yeah, no problem. And then the next question is, I want to confirm at our pre-hearing conference, you said that you would prefer not to testify as a witness. I want to confirm because some parts of your argument include statements like you saying that you had reached out to the state, not received a reply. If you would like those kinds of statements to be considered as evidence rather than argument, I'd have to swear you in as a witness. So if you would like me to swear you in as a witness so those statements can be considered as evidence, please let me know. I'd be happy to do that. Otherwise, I can let you continue with your argument.
Okay.
Would you like to be sworn in as a witness?
I was told it's not a good idea.
Okay, well, it's completely up to you. If you were sworn in as a witness, your testimony could be considered as evidence in your case. However, you would be able to be questioned about your testimony by franchise tax board. So it's up to you. I'm going to let you continue with your argument, but if you decide at any point you want to offer testimony as a witness, just go ahead and let me know and I'll swear you in. So I'm going to let you continue. And just please do speak up. Thank you.
Okay, all right, I'll try. Um, lost, where was I? Where was I? Can you repeat where I was holding? I lost. I don't know.
You were discussing how your case is similar to the appeal of Morin. And if you need anything more specific, maybe our stenographer can read back your last.
Where was it? It was determined. The appeal of Morin, right? It was determined. I don't know if I said this, but it was determined that fellow could not have kept his own records of which distribution was taxable, because those records were kept by the state, an unrelated entity, and the actual determination of which distribution was taxable was completely controlled by the state and not finalized and released to the appellate until late August 2016. I think that is referring to, not to me, but to what Moran had done. Despite requests to the commission sooner, the Office of Tax Appeal found this to be reasonable cause for the late payment of tax. In the present matter, the appellate faced similar situations with determining the taxable percentage of its income was controlled by the state based on the state records to which the appellate was denied access. In the light of appeal of Harry J. Moran, the appellate received similar relief. Access to sufficient information in the Electric and Neon Incorporated versus the commissioner, it was held that for availing the reasonable cost exception, a strong and often determinative factor in this area of law is whether or not the taxpayer has access to sufficient information upon which to base a reasonable estimate of the tax liability. In the present manner, the appellate could not have maintained his own records of which distributions were taxable, and these records were kept by the state, an unrelated entity. The determination of which distribution were taxable was entirely under the control of the state. It was not finalized or released to the appellate despite his request for information, lacking sufficient information to make reasonable estimates of his tax liability. The appellate defaulted through no fault of his own. The most important factor to determine reasonable cause and good faith is the extent of the taxpayer's effort to access his or her proper tax liability. In Farias versus Commissioner, the court carefully examined the unique circumstances of the case and noted that the taxpayer was unaware that the loan was taxable to them as a deemed distribution. Additionally, taxpayer promptly acted with relevant information being available. Based on these facts, the court concluded that the taxpayer had reasonable cause and acted in good faith in failing to report the loan as a taxable distribution. Similarly, in the present matter, the appellate failed to pay taxes on time due to lack of necessary information, but made all prudent efforts to secure the required information by making requests to the Office of the President of Operation and the Office of the Family Accountant. Therefore, the appellate should not be penalized for not receiving any response or sufficient response from them. Willful neglect refers to the conscious intentional failure of reckless indifference and the failure to exercise ordinary business care and prudence. Reasonably estimating a tax liability requires that a minimum level of information is available to a taxpayer, whether from their own records or from the information available upon request. In this case, the appellate did not have acquired the information necessary to estimate his tax liability. Therefore, the appellate inability to pay tax on by the original due date was not due to willful neglect, but rather a consequence of circumstances beyond his control, such as the unavailability of essential record and insufficient response from the state. The appellate made payment promptly at being informed of the situation when demonstrates that he had no intent to evade his life responsibility as a citizen. It has been held in the appeal of Z that although California does not have procedures for paying a late payment penalty based on the history of compliance, a consistent record of timely filing and payment compliance can still be considered as supportive evidence of the taxpayer's credibility and attempt. At the cost of repetition, the appellate reiterates that he is a law-abiding citizen and has a good filing of payment history in the past until this incident, which was not intentional on his part. His position is further reinforced by the absence of any indication that his delayed tax claims stem from prioritizing other business obligations over timely tax settlement. Contrarily, pronunciation, the appellate was punctual in paying taxes on income not associated with the state distribution and actually sought the necessary data to access his tax liability for the state's distribution. The appellate is also relying. Given the circumstances presented, to conclude, I should say, given the circumstances presented, the appellate believes that he has reasonable cause for late payment and was diligent in his effort once he became aware of the default. The appellate respectfully requests that the FTP be directed to refund the late payment penalty and estimate penalty imposed on it. That's it.
All right, thank you, Mr. Mandelbaum. I don't have any questions for you at this time. I'm going to go ahead and let FTB begin their presentation. FTB, you have 15 minutes and may begin whenever you're ready.
Good morning. I'm Yadi Lee, along with Alisa Pinar-Barcy, represent the Franchise Tax Board today. The issues are whether appellant has established, first, a reasonable cause to abate the late payment penalty, and second, any basis to abate the estimate penalty. First, the late payment penalty. It is required to be imposed unless the taxpayer established that the late payment was due to reasonable cause and was not due to willful neglect. Appellant's main argument today is about lacking necessary tax information from the estate called Eastland Trust. Appellant claimed to have requested the necessary tax information several times, but failed to obtain it and could not estimate his tax liability without it. As explained in your office's presidential opinion appeal of Moran, asserted lack of documentation or difficulties in calculating a tax liability does not by itself constitute reasonable cause. If a taxpayer asserts lacking necessary tax information to make a reasonable estimate of his tax liability, he must show the effort he made to acquire that information, such as appellant's actions, the timing of those actions, and whether they reflect an ordinary business care and prudence. Here, appellant has not provided any evidence or explanation as to his effort made. For instance, FTB is not aware of the time and method of the alleged communications, any information or document he received from the estate, whether the distribution that he received was taxable or non-taxable income, or when appellant ultimately received the Schedule K-1. To contrast, the taxpayer in Moran provided several emails and follow-ups, and asserted voice messages were left by a co-beneficiary with the estate to support his effort. and the taxpayer acted reasonably because he tried to reach out before the payment due date and after. Moran decision found the taxpayer established reasonable cause because he showed the evidence of every effort he made to get the information, as well as difficulties created by the delayed response from the estate. However, such evidence to show effort is not provided in our case. On the contrary, evidence do suggest that the appellant had sufficient connections with the Eastland Trust. To notice, appellant shared the same address as the Eastland Trust, was listed as a trustee for the trust, and used several checks titled under Eastland Trust. They all suggest a strong connection to obtain necessary tax information. Since unsupported assertions are not sufficient to satisfy a taxpayer's burden of proof, thus, appellant has not established reasonable cause because he failed to show the effort he made or the difficulty he went through. Second, the estimate penalty. There is no provision in the Revenue and Tax Code or IRC allowing the estimated tax penalty to be abated based solely on a finding of a reasonable cause. As previously established, even there is a reasonable cause exception, appellant has not met his burden to prove with supporting evidence. FTB would respectfully request that you sustain its position. I'm happy to address any questions.
All right, thank you. Franchise tax board, just to confirm, that was the conclusion of your presentation?
Yes.
All right, thanks. No, I don't have any questions for you. In that case, I'm going to go back to Mr. Mandelbaum. Mr. Mandelbaum, you have 5 minutes remaining for your closing remarks or rebuttal, and you can begin whenever you're ready.
Okay. First of all, I'd like to state before I start my rebuttal, is that Eastland Trust is not the estate. The state is not called Eastland Trust, I should say. It does pay the taxes. Rather, the communication that went on, trying to get the record was verbal. It wasn't actually written. I just want to get those two facts laid out straight. And then I'm going to start my rebuttal. This rebuttal is going to focus upon this rebuttal is going to focus upon being against estimation of late penalty based on the 16th Amendment. The 16th Amendment to the United States Constitution provides Congress the authority to levy income taxes without apportioning them among the states. The amendment was ratified in 1913 to ensure the federal income tax could be collected uniformly. While I acknowledge the government's right to levy and collect income taxes, I contest the imposition of estimation and late penalty as they extend beyond the scope of the amendment intent and legal framework. The 16th Amendment was designed to simplify and ensure fairness in the federal taxation system, enable Congress to collect taxes directly from individuals without apportionment issues. It aims at addressing the inefficiencies and inequalities present in previous tax systems, ensuring a stable revenue system from the federal government. My argument against estimation penalties. Estimation penalties impose an undue burden on taxpayers who will face difficulties in accurately predicting their annual income. The 16th Amendment authorizes the collection of income taxes, but does not explicitly mandate penalties for underestimation taxes. Such penalties can be seen as punitive measures not inherent in amendment and language or spirit. Imposing estimation penalties can create financial strain, particularly on small businesses and individuals with variable incomes, contradicting the amendment's goal of equitable taxation. My argument against late penalties. The primary purpose of the 16th Amendment is to enable fair tax collection, not penalize taxpayers for delays that may be due to legitimate financial hardships or unforeseen circumstances. Late penalties can exacerbate financial difficulties for taxpayers, leading to a cycle of debt rather than non-compliance, which is counterproductive to the amendment's objective of consistent revenue collection. The imposition of late penalties should consider individual circumstances and provide flexibility aligned with the broader principle of fairness and justice that underpin the United States tax system. Reasonable cause. We have already argued the presence of reasonable cause for any delays in inaccuracies in tax payment. Factors such as unforeseen financial difficulties, health issues, and other extenuating circumstances should be taken into account. Penalizing taxpayers who have reasonable cause for their actions is unjust and contrary to the principles of fairness that underlie the 16th Amendment and broader United States legal system. I'm going to be addressing the whole idea of taxation as an entity, it's essential to address the broader context of taxation and the principle of fairness and equality in the 16th Amendment was meant to uphold. The imposition of penalties for estimation of late payment does not align with the amendment's intent to create a fair and uniform tax system. Despite these penalties, add unnecessary burden on taxpayers, particularly those who are already struggling. To conclude, considering the historical context of the 16th Amendment, the argument against estimation of late payment and the presence of reasonable cause is clear that these penalties are unjust. The combined argument present is a just cause to rule in my favor as I highlight the need for fair and equitable approach to taxation that respects the original intent of the 16th Amendment. And that's it.
All right, thank you, Mr. Mandelbaum. So this concludes our hearing. I will decide the case based on the documents and testimony presented. I will issue a written decision no later than 100 days from today. The case is submitted and the record is now closed. This concludes our morning hearing calendar. We will reconvene at 1 p.m. for our next case. Thank you.